Yeah. Good afternoon and welcome to the Assembly Committee on Commerce and Labor. Secretary, will you please take roll?
Assembly members Anderson, Carter, Cole, Hardy, Howdigy, Kasama, Miller, Monroe Moreno, O'Neill, Roth, Torres Fawcett, Yeager, Urick, and Chair Marzola.
I am here. Please mark members present as they arrive. Welcome everyone that is here with us in Carson City, those joining us in Las Vegas, and those tuning in over the internet. Today we will be hearing three bills: Senate Bill 171, Senate Bill 258, and Senate Bill 338. I will not be taking those in order. Before we get started, I would like to make a few housekeeping announcements. Members of the public may provide testimony in various ways, which are all listed on the agenda. When testifying, please remember to turn on your microphone to speak and off to listen. Also remember to state and spell your name for the record. If you have handouts for the committee, please provide it to the committee secretary and make sure that you do have 20 copies. Committee information is available through the legislature's website. You may also watch our meeting through the legislature's YouTube channel. We ask that public comment be kept to 2 minutes so that everyone can be accommodated. As always, I expect courtesy and respect in all our interactions, even if we may not agree. I do understand that sometimes we have bill hearings that people are very passionate about, but regardless, I expect all of our interactions to always be respectful. Finally, please put your electronic devices either on silent mode or off mode, especially your cell phones. And with that, we will move to our first agenda item. I will open a hearing on Senate Bill 338, which revises provisions relating to the sale of tickets to live entertainment event. Welcome, Senator Pezzino. While you guys are getting ready, just to give a little bit of the lay of the land today, I will be limiting testimony, 30 minutes to support, 30 minutes to opposition, and 30 minutes for neutral, which means 10 minutes here in Carson City, 10 minutes in Las Vegas, and 10 minutes over the phone lines. And with that, you may begin when you're ready.
Thank you so much, Chair Marzola, for welcoming me back after my very tear-jerking bill presentation earlier this week. My name is Julie Pezzina, for the record, and I represent Senate District 12 in Clark County, and thank you so much to the committee for seeing me again here today. I'm pleased to present Senate Bill 338 concerning ticket sales for live entertainment events, and it has three main parts. It incorporates into state law a federal rule regarding ticket sales, provides for a transparent ticket refund policy, and gives the bill teeth to enforce these new provisions. Some of us who are old enough may remember times we went to a local store to buy tickets for a baseball game or a concert. The price was clearly posted. You paid cash for exactly the posted price plus any taxes. And that's been a little while. Those times are over, and most ticket sales are sold online these days, particularly for live events such as concerts as well as sporting events. And that brings me to the first part of the bill. Purchasing tickets has become an increasingly frustrating experience for consumers. When browsing for tickets, potential buyers often see an initial price that seems really reasonable. However, as they progress through the purchasing process, they encounter a series of additional mandatory fees and charges that significantly inflate the final cost. And just looking at the committee, raise your hand if you've gone online to purchase a ticket thinking it's one price and then realizing at the end it's gone up quite a bit. Yeah, it's happened to all of us. How many times have you talked to a constituent or a friend and looked at the ticket price and noticed one ticket price when you started, and by the end, it's just so much higher? And that practice, known as drip pricing, has become widespread in the ticketing industry. These fees often carry vague labels such as convenience fees, processing fees, or service charges, and they leave our constituents confused about their purpose and their necessity. The problem extends beyond the annoyance of unexpected costs. This pricing strategy effectively functions as a bait-and-switch tactic, luring our constituents in with an attractive price only to hit them with a much higher total cost at checkout. In response to these issues with ticket sales and similar fees issues in other industries, the Federal Trade Commission, or FTC, has stepped in with its trade regulation rule on unfair or deceptive fees. This final rule, which should become effective on May 12th, so very soon, addresses the lack of transparency and fairness in pricing for live event tickets. The core of the FTC's rule requires ticket providers to disclose the total price of their services up front. This total price must include all mandatory fees and charges associated with the purchase, with only a very small exception such as government charges like taxes and shipping costs not included. Under the new rule, when a price is advertised for live event tickets, the total price must be more prominent than any other pricing information. That means that our consumers, our constituents, will see the full cost they'll have to pay for the ticket right from the start, rather than being surprised by additional fees later in the purchasing process. Senate Bill 338 proposes to add these same policies set forth in the federal rule into state law. And it's necessary because we have limited influence on federal law or rulemaking, and any federal administration or commission can always change the rule. The second part relates to the refund of tickets for canceled live events from ticket providers. One of the primary issues is the lack of transparency in refund policies. Many ticket providers do not clearly disclose their refund terms at the time of purchase. This lack of clarity can leave consumers, our constituents, uncertain about their rights when an event is canceled. Another problem can be the inconsistency in refund practices. While some event organizers offer full refunds for canceled events, others only provide partial refunds, credit for future events, or in some cases, no refund at all. Even when refunds are promised, the process can be slow and cumbersome. Additionally, refunds may not include all fees paid, such as those convenience or processing fees, and that results in our consumers receiving less money back than they originally paid for the tickets for a canceled event. To illustrate, primary ticket sellers like Ticketmaster delegate refund authority to event organizers, creating a patchwork of policies that vary by venue and by performer. As documented in Ticketmaster's corporate policies, refunds for postponed events remain at the organizer's discretion, often forcing consumers to accept credit for future events rather than cash refunds. Reseller platforms sometimes exacerbate these issues. For example, TicketCenter.com's Better Business Bureau complaints reveal systematic refusal to honor refund requests for rescheduled events, even when original venues offered reimbursements. And this lack of transparency is why SB 338 implements clear policies for full ticket refunds in a reasonable time frame from the ticket provider rather than the event organizer. The third and final part of the bill establishes civil and criminal penalties for violations of these rules applicable to a large part of the ticket sale industry, including major players such as Ticketmaster and the various ticket resellers and their platforms. Senate Bill 338 adds these teeth to the bill so that our Attorney General and formidable staff of the Attorney General of the Bureau of Consumer Protection can go after bad actors who aren't playing by the rules. And right now, I would like to hand it over. I do have some co-presenters. I have Mr. Myron Martin here. Have any of you been to the Smith Center? Well, he is our CEO of the Smith Center, so he's doing a phenomenal job. I'm going to hand it to him, and then to David Goldwater, to former Senator Mike Schneider, who is with us in Vegas, and Alfredo Alonso, and this will be a short presentation. We won't be speaking much longer, I promise.
Thank you, Madam Chair. I'm Myron Martin from the Smith Center in Las Vegas. We should be proud that we live in Nevada, where, thanks to this body, we have the strongest ticketing laws in the country today. I get calls from people all over the country asking questions about our ticketing laws. What the senator has done is simply helped us bring it up to date. It's true that oftentimes people go online, they think they're paying a price for a ticket, and even sometimes after they've entered their credit card information, they're then told about all the extra fees. And they don't know to turn back and cancel the thing, or since they've already put in their information, I guess I need to just go ahead and pay the fees and tough it out. Well, the reality is consumers deserve better than that. Many of the places, like the Smith Center, already have all-in pricing from the very first screen as you just do your first search for a ticket. At the very beginning, we tell you what the total price is. We think everyone should. Let me just say, because through the years, as we've talked about the ticketing bills that Nevada is so proud of, I have always said that we're not against secondary ticketers. We're not against people who resell tickets. We're just against people who do things in an unscrupulous way. Our bills and the senator's update will help us do that so that consumers in our city will be protected. And the FTC has made their changes, which actually help us. There's a model there for us to follow for all-in pricing. So with that, I thank you for your support. I thank the senator for putting this forward, and we will continue to be the best ticketing state in Nevada, I think. Thank you very much.
Thank you, Madam Chair. David Goldwater, representing the Nevada Ticket Brokers Association. Gratitude to Senator Pezzina, who picked up the mantle from Senator Joyce Woodhouse, whose legacy you find in these statutes. I'd like to direct your attention also to a letter from Gary Adler on your Nellis from the National Ticket Brokers Association, who covers this subject well and in depth, and I won't read it here for you. The ticket brokers whom I represent are Nevadans, and this creates some consistency among the platforms because their reputation is based on trust, on what the constituents and our visitors who we love and value so much, they are there constantly. And this consistency helps them regain that trust, because you can imagine trying to sell something online and your quoted price is a lot more than what it ends up being when your competitor has something quoted lower, but the fees are so much more in the end. Again, wanted to and thank not only Senator Pezzina, but oftentimes we are, in previous legislative sessions, my friend Myron and Mike Schneider and my good friend Alfredo have been on the opposite side of these issues. This happens to be one of those where Senator Pezzina has brought us all together and has a bill in front of you that I think we all support. So gratitude and thank you. I'm happy to stand for any questions.
We are going to go to Las Vegas and former Senator Schneider, and then we'll end with Alfredo Alonso and be ready for questions. Thank you.
Mike Schneider here in Las Vegas. I know a lot of you are new to the legislative process. Just to bring you up to speed, we started working in the legislature on ticket pricing and about 30 years ago, and it's slowly moved forward, all right, over this time. And let me give you a little bit, if Myron will allow me. The Smith Center sells their tickets, and their tickets only cover 75% of their cost. So they take a 25% loss on every ticket they sell, and that's to keep the tickets affordable for the public here in Las Vegas and anyone who travels in. So they've worked real hard to do that, and they have to raise money and everything to cover the cost. And the Smith Center, when they've had big plays in past years, Hamilton and the Book of Mormon and that, people were scalping those tickets and selling them for hundreds of dollars, and it really offended the ticket holders who maybe had their tickets purchased for $75 or $100 total, and now if they wanted to get tickets for friends or family, they were paying hundreds of dollars, and they were really offended. So we've helped eliminate a lot of that. And just to let you know, I read the story where Taylor Swift, on her tour last year, people were buying tickets in Paris, flying to Paris to see Taylor Swift's concert, and they were paying less money on the whole trip and the tickets than buying scalp tickets in the United States, which is really offensive, should be offensive to all of us. Anyhow, I want to thank everybody for working on this bill. And I know Myron is thankful that this session we have not a big argument over it. And I will be here for any historical questions anyone has. Thank you.
Thank you so much. And as the former senator mentioned, Taylor Swift, happily this bill has so far caused no bad blood. And now to Alfredo Alonso.
Wow. Madam Chair, members of the committee, Alfredo Alonso, today representing UFC, the Vegas Golden Knights, and the A's. And yeah, we've been part of all these discussions and these debates ever since 2017, and I think we've gone a long way. And this is the first time you would see David and I at the same table agreeing. And it goes to the fact that they're locals. They care about the locals, and at least from a standpoint of making sure that it's clear to everybody from a consumer standpoint, that pricing, the cancellation policies. Again, these are all things that we all do now, and so putting this in statute and making sure that it's clarified going forward. We can't always control what some of the sites that are obviously outside of the state, but it's a good start, and that between this and the FTC, you hope to get most of it and at least bring some clarity and consumer protection. Thank you.
Thank you so much for allowing us to present today. Julie Pizzina for the record, and we stand for any questions.
Thank you, Senator, and thank you to all that have joined you at the table and in Vegas today, and for keeping it brief. We appreciate it. Committee members, are there any questions? I don't see any. That's how you know the presentation went well. We will start with support testimony of Senate Bill 338. Is there anyone in Carson City wishing to testify in support? Please remember to state and spell your name for the record.
Thank you, Chair Marzola and committee members. Misty Grimmer, Grimmer, representing the Nevada Resort Association. We definitely appreciate the goals of this bill and also appreciate Senator Pizzina for working with us on the amendments to make it more acceptable to our members. Thank you.
Thank you for your testimony. Is there anyone else in Carson City wishing to testify in support?
Good morning, Chair Mazzola. Andre Wade, ANDREWADE. Here in my personal capacity, here in support as an avid ticket buyer of concerts and shows. I need this in my life. Thank you.
Thank you for your testimony. Is there anyone else in Carson City? I don't see anyone. Is there anyone in Las Vegas wishing to testify in support of Senate Bill 338? I don't see anyone walking up. Broadcast, is there anyone on the line?
To testify in support for Senate Bill 338, please press *9 or raise your hand in the Zoom window to take your place in the queue.
Hi, my name is Katrin Ivanov. Last name I-V-A-N-O, Frank. Thank you for the opportunity to testify. I'm in support of the bill as presented, especially with the extra presenters from Mid-Center and Mr. David Goldwater and Alfredo Alonso. I would support anything that is for consumer protection, and I'm glad to finally hear a bill that is actually going to be helping Nevadans, and by the looks of it, not only Nevadans, but I'm mostly concerned with Nevadans. Thank you. Have a lovely day, and I'm sure you will hear my lovely voice soon.
Chair, the public lines are open and working. We have no more callers for support at this time.
Thank you. We will move to testimony in opposition of Senate Bill 338. Is there anyone in Carson City wishing to testify in opposition? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition? Broadcast, is there anyone on the line?
To testify in opposition to Senate Bill 338, please press *9 or raise your hand in the Zoom window to take your place in the queue. Chair, we have no callers for opposition at this time.
Thank you. We will move to neutral testimony. Is there anyone in Carson City wishing to testify in neutral? Please remember to state and spell your name for the record.
For the record, Jessica Ferrato, Ferrato, here on behalf of Burning Man. Madam Chair, members of the committee, thank you for your time. I want to thank the proponents and the sponsor for all their work on this bill. We did have concerns in the first House, and those concerns have been removed. Want to appreciate all the work put into this bill. It's been a lot. Thank you.
Thank you. Is there anyone else in Carson City wishing to testify in neutral? I don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral of Senate Bill 338? Broadcast, is there anyone on the line?
To testify in neutral to Senate Bill 338, please press star 9 or raise your hand in the Zoom window to take your place in the queue. Chair, we have no callers for neutral.
Thank you. Senator, I will now close the hearing on Senate Bill 338. I will now open the hearing on Senate Bill 171, which enacts a shield law to protect the transgender community. Good afternoon and welcome to Commerce and Labor. You may begin when you're ready.
Good afternoon, Chair Marzola, members of the Assembly Commerce and Labor Committee. For the record, my name is James Orenshaw. I represent State Senate District 21 down in Southern Nevada, and I'm very fortunate to have with me co-presenting Andre Wade, the Executive Director of Silver State Equality. And on Zoom, I believe I have Rob Phoenix, who's an advanced practice registered nurse who is a healthcare provider and has tremendous experience in this area, and we'll be able to talk about the issue with a lot of medical detail that I may not be able to provide. Some of the committee may remember policies from this bill, from Senate Bill 171 that I sponsored last session. That bill did pass both houses of the legislature. Unfortunately, it was vetoed by the governor. I spent countless hours with stakeholders going over the governor's veto message for that bill, and I believe that Senate Bill 171 that you have in front of you addresses many of the concerns that the governor had in his veto message of the prior bill. Many states have passed laws making gender-affirming care illegal, even when medically necessary and provided with the informed consent of patients and their families. Between 2018 and 2022 alone, 48 laws against the transgender community, which restricts the rights of transgender and non-binary people, were passed by 19 different states. According to CNN, 26 states have passed bans on gender-affirming health care for transgender children and teenagers. These bans have a pervasive effect and have already caused significant harm to these patients. For example, a recent study estimated the impact of state-level anti-transgender laws on suicide risk for young transgender and non-binary people between 13 and 24 years of age. That study found a statistically significant increase in the rate of suicide attempts for this community in the years immediately following the enactment of state anti-transgender laws relative to states that had not passed such legislation. The study authors concluded that these findings highlight the need to consider the mental health impact of recent anti-transgender laws and to advance protective policies. These state actions not only harm transgender individuals, but also create a climate of fear and uncertainty for healthcare providers who offer gender-affirming healthcare services. For example, anti-transgender laws impose severe punishment for healthcare practitioners that provide such services, in some cases with stiff prison sentences and very large monetary fines. Keep in mind that gender-affirming healthcare services are medically necessary treatments for individuals who experience gender dysphoria. According to the most recent Diagnostic and Statistical Manual of the American Psychiatric Association, this condition results from a mismatch between an individual's gender identity and the sex assigned to them at birth. Senate Bill 171 addresses the growing concern about these laws across the country that have made gender-affirming medically necessary health care illegal. and the potential for discrimination against transgender and gender nonconforming individuals. Senate Bill 171's objective is to establish a shield law in Nevada that protects patients and providers of gender-affirming health care. I would like to now summarize the sections of the bill. Section 1, subsection 1 prohibits healthcare licensing boards from disqualifying or punishing a licensee solely because the licensee provided or assisted in providing medically necessary gender-affirming healthcare services or was subject to judgment, discipline, or other sanction from another state for providing or assisting in such gender-affirming healthcare services. This protection of healthcare providers applies only if the services were provided with parental consent, except if Nevada law would expressly authorize a minor to consent to such services. Subsection 2 of Section 1 sets forth detailed definitions for gender-affirming healthcare services, healthcare licensing board, and medically necessary. Section 2 prohibits the governor from surrendering or issuing a warrant for the arrest of an individual who is charged in another state with a crime that involves providing, assisting, or receiving medically necessary gender-affirming healthcare services, unless such acts are also considered criminal acts in the state of Nevada. In addition, Section 2 excludes from this prohibition circumstances where executive authority of another state demands the surrender of a person who is physically present in the demanding state at the time of the commission of the alleged offense and then fled from that state. Section 3 prohibits state agencies in the executive department from providing information or using certain resources to assist in an investigation or proceeding initiated in another state related to providing, assisting, or receiving such services, except under certain limited circumstances. Finally, Section 4 requires healthcare licensing boards to examine the feasibility of providing licensure reciprocity for out-of-state providers of gender-affirming healthcare services to ensure that people seeking these services have access to this healthcare. With your permission, Chair Marzola, I wonder if I could turn it over to Andre Wade and then to Rob Phoenix. Then I'm happy to answer any questions.
Good morning again, Chair Marzola and members of the committee. My name is Andre Wade, ANDREWADE, and I am the State Director for Silver State Equality. I just want to start off by thanking Senator Orenshaw for bringing forth this bill that will help to provide protections for our healthcare providers here in Nevada. There are reports that dozens of parents are calling LGBTQ plus centers in Nevada from neighboring states like Utah and Idaho to find out about how they can access care for their child. These are parents who are advocating on behalf of their children, and these are parents who want the best for their children despite the obstacles ahead of them. Regarding providers, we have a documented shortage of providers in Nevada, which also includes mental health providers. We need them to know that they have protections when they deliver care that is legally available to patients. We need healthcare providers to stay licensed here and not choose to leave because they don't have necessary legal protections from other states that may want to overreach into Nevada and impose their laws. For example, in November 2023, the Texas Attorney General attempted to seize records of transgender patients from a Seattle children's hospital months after a Texas law banned puberty blockers and hormone therapy for transgender youth. The move was characterized as Texas testing how far it could extend its gender-affirming care restrictions beyond its state lines. Eventually, the case was settled, and the hospital in Seattle did not have to provide those records to Texas or any other information. And there was a similar attempt by the Texas Attorney General and a healthcare provider in the state of Georgia. Additionally, there is a bill pending in Texas that proposes in-state liability for someone in Texas who refers a child to a healthcare provider in another state, creating the threat of subpoenas seeking medical information in Nevada with which to prosecute therapists, pediatricians, pediatric endocrinologists, and others in Texas. Last month in Arkansas, there was a bill that was introduced that would allow lawsuits to be brought against people outside of Arkansas if they are deemed to have helped a transgender child transition. The way the bill defines transition not only means for medical care, but also for social transitioning like clothing, pronouns, hairstyle, and names, which is a core function of gender-affirming care. The penalties that the bill proposed is $10,000 per defendant, with punitive damages reaching up to $10 million for those involved in medical care. These bans on gender-affirming care started off by targeting young people. However, there are some states like Ohio that are attempting to restrict care for adults. There are states like Florida that are attempting to greatly restrict access to care for adults, causing some to seek care in other states. These are some real-life examples of real threats out there to providers and families seeking care in Nevada that is legally available to them and, broadly speaking, covered by certain insurance companies depending on the individual plan. We simply don't want other states imposing their laws on us here in our great state of Nevada. So in conclusion, SB 171 would by no means decrease the state of Nevada's authority to be able to provide oversight for medically necessary gender-affirming care here in Nevada. If anything, provide stricter scrutiny by emphasizing that care cannot be provided simply because someone wants it without any basis of need. Also, this bill would not give cover to any healthcare provider who provides services not congruent with Nevada law. That concludes my remarks, and if I may, send it over to Rob Phoenix.
Thank you, Chair Marzola and members of the committee. My name is John Phoenix, Phoenix. My preferred name is Rob, and I use pronouns of he, him, his, and they, them. And I choose to use pronouns in support of the members of the community that I identify with, which is the LGBTQ community. I am a family nurse practitioner in Las Vegas. I have been providing primary care, including gender-affirming care, since 2013. I became certified by the World Professional Association for Transgender Health under Standards of Care version 8 in 2023. And I am providing testimony today in support of SB 171 as a medical expert in gender-affirming care. My testimony does not reflect the views or opinions of any of my employers. Here's an example of how this bill will protect me as an advanced practice provider. I have a patient who resides in Florida. He's 33 years old. He comes to Las Vegas for his gender-affirming care. I complete my evaluation in Nevada, in my clinic in Las Vegas, and determine through the conversation and review of his medical records that he is an appropriate patient for testosterone for gender-affirming care. This patient subsequently returns back to his home state of Florida and needs to seek care for another unrelated a condition unrelated to his gender-affirming care. During the course of that visit, the provider does his due diligence and completes a medication reconciliation and identifies that this patient has received testosterone for gender-affirming care from a provider licensed in Nevada. That provider could report me to the Board of Nursing in the state of Florida, where I am not currently licensed, and try to come after my license in Nevada, where I am licensed as an advanced practice registered nurse. I have the appropriate federal DEA allowing me to prescribe medication schedules 2 through 5, and I also have a Nevada Board of Pharmacy controlled substance prescribing license. Nevada will protect our providers by offering and bringing this bill forward. In Florida, it is not only illegal for children to receive gender-affirming care, there are limitations on the ways that adults can receive gender-affirming care as well. In 2023, Florida passed a bill, 1421, that will prohibit healthcare providers, except Florida licensed physicians, and physicians employed by the federal government from providing sex reassignment treatment. Physicians must obtain in-person informed consent on a form adopted by the Board of Medicine or Board of Osteopathic Medicine. Each time the physician provides sex reassignment treatment, other than prescription renewals for which the patient has previously obtained the consent. The bill requires the Department of Health to issue an emergency order suspending the license of any practitioner who provides sex reassignment treatment to minors. The Department of Health or the applicable board may take disciplinary action against the license of a practitioner who violates any of the requirements for sex reassignment treatment and imposes criminal penalties for certain violations. Additionally, per this bill, in addition to the disciplinary action, the bill imposes criminal penalties for certain violations. A healthcare practitioner who willfully or actively provides sex reassignment treatment to a minor commits a third-degree felony, and any healthcare provider who fails to obtain informed consent commits a first-degree felony. All these things outlined in the Florida law are permissible in Nevada and within my scope of practice. And they are services that I've been providing and plan to continue providing in the future. There are currently 27 states, as we have heard, that ban Americans from accessing life-saving medical gender-affirming care. Nevada would become one of 17 states that offers shield laws for providers in Nevada. When individuals are denied care, there is an abundance of literature that outlines the harm that is caused to the patient and the family. Organizations such as the American Medical Association, American Academy of Pediatrics, the American Nurses Association, have all issued statements regarding the harm that exclusive policies towards gender-affirming care have on our populations, specifically the gender diverse youth populations. In addition, the American Psychological Association has published guidelines in support of psychological care for transgender and gender diverse individuals. For over 20 years, studies have demonstrated the highly marginalized experiences of this community and the high rates of mental health needs and suicide. In 2022, Denise Rivera and her colleagues published an introduction to Rivera's gender-affirming nursing care model, which is a middle-range theory which sets an expectation for nursing to support gender-affirming knowledge and care practices within the domain of nursing to improve health based on the systemic bias and discrimination experienced by transgender individuals within the healthcare systems. This law, when passed, will protect over 77,000 licensed healthcare providers in Nevada. This includes advanced practice registered nurses, such as myself, physician assistants, MDs, DOs, registered nurses, licensed practical nurses, medical social workers, speech therapists, speech therapy assistants, occupational therapists, occupational therapy assistants, and physical therapists and physical therapy assistants. The Bureau of Labor Statistics projects that nationwide there will be over 200,000 nursing vacancies by the end of 2025. What I'm educating you about today is the well-documented history of the negative effects of denying access to medically necessary care, especially within a marginalized community such as the LGBT community. We can produce hundreds of pieces of peer-reviewed literature that continues to demonstrate the harms that policies like this have. We can share numerous peer-reviewed articles addressing the educational deficits of healthcare providers and healthcare provider training regarding our failure to include this relevant training in our programs and how that contributes to the negative experiences marginalized communities experience. We can also support this medically necessary care with evidence-based guidelines from organizations such as the Endocrine Society and the World Professional Association of Transgender Health. Nevada already sits towards the bottom of the list of healthcare shortage professionals. Protections such as what this bill offers to patients and providers are desperately needed. As a healthcare provider, our goal is to provide evidence-based care. This bill allows us to do that without fear of prosecution from external states. As a point of clarification regarding misinformation shared during the Senate hearings on this same bill, Senate Bill 171, Section 1, Subsection 1A, healthcare licensing boards shall not disqualify a person from licensure or subject a person to discipline solely, A, for providing or assisting in the provision of medically necessary gender-affirming care services, or B, as a consequence of any judgment, discipline, or other sanction, threat, or imposed under the laws of the District of Columbia or any state or territory of the United States for providing or assisting in the provision of medically necessary gender-affirming healthcare services, if the gender-affirming healthcare services were provided with parental consent, unless the minor would have been expressly authorized to consent to those services under the laws of the state, and the services as provided would have been lawful in the state. That is what this bill does. It does not prevent licensing boards in Nevada from refusing to issue license to MDs, DOs, NPs, PAs, etc., if they have other discipline on their license or other restrictions per the respective licensing boards. So the repeated statements that this bill will open up the floodgates for providers who lost their license in another state and lower the quality of care of healthcare providers in Nevada is classic misinformation and needs to stop. Misinformation like this is harmful and creates dangerous conditions for healthcare providers regarding our ability to provide medically necessary care, regardless of the medical condition we are treating. The protections of this bill will enable families and patients to receive the medically necessary care that they need for their medical conditions. Our ask for you as the legislators is very simple. We are not asking you to step into the exam room with us and help us in guiding decisions between patients and parents and providers. We are asking you to help protect access to that care by providing legislative protection for us to do our jobs, and that is to provide medically necessary access to gender-affirming healthcare. Thank you.
Thank you very much, Chair Marzullo. Thank you, members of the committee. Senate Bill 171 is about patients. It's about providers of healthcare. It's about medically necessary healthcare and not having other states interfere with legal healthcare in Nevada and with patients and their healthcare providers. Happy to answer any questions.
Thank you, Senator, for being with us today and presenting such an important bill. I do have a quick question before I pass it to my committee members. You stated that this version of your bill addressed the veto message that the governor had. Do you have that veto message with you?
Thank you, Chair. James Orangeville, Senate District 21.
And if you don't, it's okay.
I can pull it up real quick.
I don't want to put you on the spot.
I've looked at it umpteen times, and yes, and I do have the gist of it. Thank you very much. Thank you, Andre. Governor's veto message from 2 years ago, as to the bill I sponsored back then, Senate Bill 302. The crux of it was Senate Bill 302 inhibits the executive branch's ability to be certain that all gender-affirming care related to minors comports with state law. It also decreases the executive branch's authority to ensure the highest public health and child safety standards for Nevadans. As such, I cannot support it. And I do believe here that Senate Bill 171 in front of you it's not Senate Bill 302. It is almost word for word what we've enacted in statutes on reproductive health care, trying to protect patients and providers of health care. That is the law. It's been the law now since 2023. That was sponsored by Majority Leader Cannizzaro. That, as far as I know, has not had any successful legal challenges to it. And I believe that protecting legal health care, protecting patients is important. I hope this addresses the governor's concerns. I hope the committee will consider moving forward with it. But
Thank you so much. We will start with questions. Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. Actually, just going off what you said, I'm actually very proud when I was in the former administration's office to have drafted the 2022 executive order that protected patients and providers seeking care in the state, both for reproductive health care as well as gender-affirming care. One thing, and I see a lot of that language mirrored in this bill, and that was also mirrored in the bill that was brought last session by the Senate Majority Leader. And so one thing that I think gets lost in the conversation a lot is the point of reciprocity. And I know that when we had originally discussed that language, there was a lot of discussion around the importance of ensuring that we were creating an inviting and safe atmosphere for providers to be in this state who are providing legal and evidence-based life-saving care. So can you speak to that reciprocity piece a little bit more?
thank you very much, Chair Marzola. James Orangeville, Senate District 21. Through you, Assemblymember.
Go direct.
Oh, thank you. Thank you, Assemblymember Roth. You know, as with the discussion regarding reproductive health care, I think here, the physicians who provide gender-affirming care, it's not a large number in the whole state. So that's why Section 4 of the bill talks about healthcare licensing boards examining reciprocity and trying to let other providers know that Nevada will be a safe environment if they want to practice medicine here, medicine that is legal in Nevada. Last session, we had testimony from physicians, from a resident that was about to, I believe, start their work at a hospital, and the testimony was that that doctor was worried they'd have to leave the state if we didn't pass a law like this. And I believe they are practicing now in another state. So I think that if this passes, if healthcare licensing boards do study that reciprocity, and we do have physicians that know Nevada is a safe atmosphere to practice law, it'll attract more physicians. And with your permission, Chair, could I defer to Rob Phoenix too? Thank you. I think he might be able to address that point too.
Thank you, Senator Orangeville. John Phoenix, Phoenix, for the record. This will open up an opportunity for providers. One of the challenges that we are experiencing right now, as Senator Orangeville mentioned, is lack of access to providers who are experienced and willing to provide gender-affirming care. It limits patients' abilities to seek care. We have one surgeon, a plastic surgeon in town, that will participate in gender-affirming surgeries with patients with Medicaid. A significant number of patients who are seeking treatment for gender-affirming care have Medicaid as their payer source, and that severely limits their ability to seek services. Thank you.
Assemblymember O'Neill.
Thank you, Chair, and thank you for presenting the bill. We had a very good conversation yesterday on this, and I've had time to digest it. And the gentleman down in Vegas brought up an interesting point to me. If I understood him correctly, he said that he's licensed here in Nevada, is not licensed in Florida, and that Florida could come and go against his license here in Nevada. I'd like to have that explained to me a little better. If what he is doing, and from what I understand, he is performing legal, appropriate care services here in Nevada. So how and or why would his licensing board here in Nevada damage his license here in Nevada? I don't see the correlation between Florida coming out here and trying to take his license away when he's legal. If either he or any of you could help me understand that, I would greatly appreciate it.
Thank you. James Orenshaw, Senate District 21. Thank you, Assemblymember O'Neill. And Chair Marzullo, I just want to let you know my co-sponsor on the bill, Senator Scheibel, joined us today too. And the specifics that Rob mentioned, I'd like to defer to Rob. But certainly as to my desire with Senate Bill 171 is that if someone is practicing in another state and that state has passed a law that has now made gender-affirming care illegal, that when they travel to Nevada, if they want to practice here, a licensing board here is not going to prohibit them from practicing here. So with your permission, may I defer to Rob Phoenix? Thank you, Chair.
Thank you, Senator. Rob Phoenix, for the record, Phoenix. So my reference is in the state of Florida, as a nurse practitioner, legislatively, I am prohibited from offering gender-affirming care. In the state of Florida, if I were licensed there, I would be legislatively prohibited from prescribing testosterone. In the state of Nevada, both of those things are under my current license and within my scope of practice and my specialty areas. So many of these laws, like Texas and Florida, are seeking to attack externally licensed individuals such as myself for providing services to Florida residents. And the last time I looked at the Constitution, people don't belong to a state. We are unique individuals. So allowing individuals to seek care that they feel is appropriate and allowing providers to offer medically appropriate and medically necessary care without fear of retaliation, like we're seeing in many instances in our current administration, these are the things that this bill will help to protect us from. These are my real concerns. Another issue that we are experiencing, as I mentioned before, we have a shortage of providers. We struggled to find providers who were willing to come forward and testify in the Senate hearing and in this hearing because of fear of retaliation. This is a real struggle. This is real impact on patients. These are things that are contributing to worsening outcomes for patients, because not only are they seeking gender-affirming care, but I'm providing them primary care as well. So I'm helping to manage their diabetes or their high blood pressure or their HIV or whatever medical condition they have. And very frequently, supported by tons of literature that's peer-reviewed, we see patients dropping out of care because they don't get access to what they feel is most important, which is their gender-affirming care. So when we build bridges like this for patients, allowing them to seek gender-affirming care, we get them into care and we lower our cost and we lower our mortality and morbidity for all these other things that are much more likely to kill people other than suicide. And when we put barriers in place that prevent patients from coming in, then our healthcare outcomes go down, our morbidity, our mortality rates go up, and our suicide rates go up as well. Thank you.
And I appreciate that, as you said, you're providing care that's all legal, which is fine. But I'm asking about, and you use the words may come after you, if they come after you, something may happen, but can you give me an incident that has actually occurred where Florida, Texas, or one of these other states has come after you for providing the care that you're providing legally in the state of Nevada. That's what I'd like to hear, because I'm questioning the need for this bill, in all honesty. I'm not talking about your ability to provide your services. I'm talking about your licensing, that you say Florida may come after you. May, other providers, they may come after them. Well, a lot of things may happen in the future. So that's where I'm going, and I apologize if it's argumentative. I'm not questioning. You go off about the care you provide. That's fine. Talk to me about your licensing, please.
So Rob Phoenix, Phoenix for the record. So as Mr. Wade noted in his opening statements, there have been attempts by the state of Texas to go after providers outside of the state of Texas for providing gender-affirming care to adolescents. Have I been personally impacted by this? Not yet. No state has come to me for providing care to a person who was a resident of their state and said, hey, what you've done is illegal in our state. We're going to attack your license. That has not happened, fortunately. And if in the event that that does happen, the protections that this bill will offer will allow me to continue to practice in the state of Nevada, offering care to patients, which without protections like this, I'm hanging out in the wind. And there's anybody can come after me for doing something that they are unhappy with, which is where most of this comes from. I hope that provided better clarity.
Thank you. I appreciate it. Thank you, Chair, for the time.
Assemblymember Cole.
Thank you, Chair. Thank you for the presentation. So my question is in Section 3, Sub 1. Understand the civil and the criminal liability portion, and this is in regards to our agencies providing information in regards to an investigation that's launched, right? So this prohibits them doing that. But my question is on the professional sanction part. And I bring this up because, and I didn't catch all of the accreditation that the gentleman had mentioned, but he's got a couple of accreditations from various organizations on gender-affirming care. And so I'm just wondering if having the professional sanction in there would provide a shield when he's maybe not doing something that he's doing something he shouldn't be doing under those accreditations, if that makes sense. And they're trying to make sure that he's doing everything correct, and then these agencies wouldn't be able to provide the information.
Thank you. James Orange, House Senate 21. Thank you, Assemblymember Cole, for the question. My intent with Section 3, and this mirrors the language in what we passed regarding reproductive health care last session, is that no healthcare provider in this state would be penalized because legal medically necessary care in Nevada would have been now made illegal in another state, or that a board would sanction them or prevent them from practicing here in Nevada. So that's certainly my intent with Section 3. And I'd be glad to defer to Rob Phoenix if there's any additional information that he can provide, Chair, with your permission.
Thank you, Senator Rob Phoenix, for the record. So as part of the credentialing process for my certification for any of my nurse practitioner or anything, I have to maintain an active license to practice as both a registered nurse and an advanced practice registered nurse. So if my license as a registered nurse or an advanced practice registered nurse is impacted negatively by a practice decision that I made or something that is outside of my scope of practice, then that would inhibit my ability to continue to be accredited or certified by these external organizations like WPATH. I hope that provides more clarification. I'm happy to try to address it differently.
Assemblymember Urick.
Thank you, Chair and Senators. Always good to see you guys. Mr. Wade, pleasure to see you as well. Thank you for taking the time to come answer our questions. I thought my colleague was going to address my question, and then hers fell slightly short. So, and I didn't think about this question until, I didn't think about this till yesterday. By the way, I appreciate the lobbying efforts to come in and talk about this bill and what its intent was. But something occurred to me yesterday that when these similar bills with the reproductive and this bill last session, it didn't occur to me as a freshman. But one of the things that I'm really proud of this session that we have been doing is this bipartisan effort to increase access to health care in Nevada by entering into these licensure compact agreements for healthcare providers. And including, in fact, quite frankly, including our chair's own Assembly Bill 450 with marriage and family therapists and the Counselors Pact. But all of these compacts, I went back and looked, and it seems like all of these compacts actually require us to be transparent, to share disciplinary records, and basically cooperate with disciplinary matters. And so the Section 3, Subsection 1 provisions appear to prohibit our board's ability to act on, communicate with, on any issues that address gender-affirming care. And so my question is there any concern that if this bill were to be enacted and become law, could this put us at odds with some of our other attempts to engage in these compact licensure agreements and increase access to healthcare in Nevada?
Thank you, James. Thank you, Assemblymember York. James Orenshaw, Senate 21. Certainly, we have very similar language regarding reproductive health care now, and as to how it might affect, in particular, your question, I'm not sure I have the answer to that question. So that's something I can try to find some more information, get back to you. Perhaps, Chair, if Mr. Phoenix might be able to talk about that a little bit, but unfortunately, I don't have an answer right now to that question.
Mr. Phoenix, if you're able to answer, that's great. If not, I just ask that any questions that you guys aren't able to provide the answer to today, if you can please email the entire committee with those answers. But Mr. Phoenix, if you can answer, please go ahead.
Sure. Thank you, Chair. Rob Phoenix for the record. So the nurse licensure compact requires that an individual be licensed in their home state. So if they are not able to receive a license in their state because of some violation of a law that would restrict them around providing gender-affirming care, then that would prevent them from being able to grant that individual a license under the compact. Currently, there are 43 states that have nursing compacts. There are 4 states that have nurse practitioner compact agreements. But the crux of it is the person has to maintain their state of residence licensure. So if somebody in Missouri is living in Missouri, they have to maintain their Missouri license in order to be able to get this multi-state or compact licensure state, which basically opens up our opportunity to bring in other nurses and nurse practitioners potentially in the future to help solve some of our shortages. So there are benefits to the nurse practice or the nurse compact, but it relies on the home state issuing a valid license. They also have to have passed the NCLEX exam, which is the basic exam that all nurses have to pass in order to receive a license from any state. And they have to have graduated from an accredited program that is accredited by their boards of nursing, which is also a core requirement of every state licensure. Each state has different requirements in addition to those around licensure, but the core is that they have to meet their basic home licensure requirements in order to be able to participate in this. I hope that answered the question.
I really appreciate the effort to address my concerns. I'm not sure that I'm fully satisfied that it addressed the breadth of those concerns. Again, reiterating, my concern is literally to these compacts and what our obligations are to remain a part of that compact, share disciplinary information, cooperate with investigations and those sorts of things, not just in the nursing one, which I understand has an uphill battle here in Nevada, but there's other ones, right, that have similar cooperation provisions and communication standards that I am just concerned that perhaps this bar to communicating and cooperating with these types of investigations could create a problem. And so I would appreciate any help you can do to satisfy my concerns about that.
Thank you very much, Chair. Thank you. And I wonder, Chair, if I could ask your indulgence for just 1 second. I know Senator Scheibel is going to be starting Senate Judiciary soon. I wonder if she might be allowed to just make a brief statement in support of the bill. She's my co-sponsor and has helped me tremendously on this bill with your permission, and then go back to any questions.
Senator Scheibel, would you like to make a statement?
Sure. Thank you so much for having me, and I apologize for being a little bit late to the meeting, but I do wholeheartedly support SB 171, and if I could maybe address some of the concerns and some of the questions that I've heard since I've been here. I think that SB 171 is really, it's a forward-looking measure, and it's also very specific to our time. As a lawyer, I think a lot of the questions came from lawyers about how this how we find ourselves in this position to begin with. And I think actually Assemblymember O'Neill's question kind of went to, how is this even possible? How can a Florida licensing board in any way come after or go after a Nevada physician? And I think the answer is they shouldn't be able to. They shouldn't. But we have seen that this has started to occur, especially with providers of reproductive health care. I think in the last year, there was a doctor in New York who was providing abortion services for whom a warrant for her arrest was issued by the state of Louisiana. Now, I think there are obviously political undertones to the issuance of that arrest warrant, and I do not think that it is a stretch to be concerned that the same might happen to providers of gender-affirming care. And so the purpose of SB 171 is to be responsive to that, what I think is frankly a strange reality we live in, where people are so concerned about what folks in other states are doing that they disagree with, that they're willing to go through the court system and get a warrant issued for their arrest. We are saying proactively in Nevada, we're not going to participate in that kind of a perversion, frankly, of the U.S. Constitution. We are not going to be a party to these cross-jurisdictional attacks on providers who are providing legal, safe, quality health care in their home states. And before 2021 or 2023, there really weren't these concerns, because this didn't happen, because states regulated the doctors and the nurses and the nurse practitioners in their own states, and they did not worry about what nurses and doctors and nurse practitioners did across state lines. That's no longer the reality. And so that being the case, it becomes incumbent upon us to protect our providers from these outside forces, and that's the purpose of SB 171, is to provide that assurance to somebody who decides they want to live and make their home in Nevada, and they want to provide healthcare services to our residents, to be able to say to them, we will protect you when you do that within the scope of your practice and under the standard of care. We will not participate in this kind of witch hunt that's going on across the nation, and we will not aid other jurisdictions in coming to not just attack their license, not just to prevent them from practicing, but to engage in this political process to undermine their ability to practice medicine. And I think that goes similarly to the compacts, that there is a difference between being part of a compact and meeting the provisions of that compact to provide helpful, useful, relevant information across state lines versus saying that we are cooperative. We do want to work with other states in certain circumstances to ensure that providers are able to, the other issues with compacts aside, and as someone over here pointed out, it's an uphill battle for the nurses here in Nevada. But there's a difference between saying we are going to have communications with you versus we are going to take some responsibility for the attacks that are occurring outside of Nevada, and we're not going to be party to that. We are not going to engage in what is a glorified gossip chain to tell on providers here who have been attacked by licensing boards outside of Nevada and further contribute to their humiliation and their degradation by passing on that information to another licensing board. We can still craft agreements that allow us to report actual violations and actual disciplinary concerns with providers to those other states, those other licensing boards, without stooping to the level that other states are going to now and mudslinging across state lines about providers who are absolutely following the standard of care and providing legal care to their patients. And so I think about the people in Nevada, especially the young people who depend on their healthcare providers to allow them to navigate this life, that allow them to access mental health care, that allow them to, gender-affirming care isn't just hormones and surgeries. Gender-affirming care is going to a doctor who utilizes your preferred name. It's going to a doctor where you're not embarrassed to say that you have some medical condition going on that's unusual for children of your age or your sex or your gender. It's being able to be comfortable going to a provider knowing that they are not going to make you to feel bad about being the way that you are. And so I want Nevada to be a place where doctors can do that, and nurses and nurse practitioners and healthcare providers can provide those supports to Nevadans of every age. And that's why SB 171 is important. It's important for us to stand with those healthcare providers in order to stand with our constituents.
Assemblymember Miller.
Thank you, Chair, and my question as well keeps changing form. Most of us have always heard of people going, and I'm saying this in regards to reciprocity for the patient as well as the practitioner, right? There's many instances, if we all think personally, where people have gone out of state, even to Canada or Mexico for, I literally was writing a list, for surgeries, medication, transplants, dental work, weight loss, cosmetic surgery, counselings on Zoom, and even hormone therapy that doesn't have anything to do with any type of trans healthcare, right? And in none of those cases, do I believe, has there ever been a concern about the practitioner losing their license, the patient facing any type of sanctions. And again, the bill already referenced that we're talking about care and conditions that would be defined in the DSM, which usually says this is medically necessary. And I also know the DSM is full of many conditions that not everyone supports, believes, understands. But again, they're there for a reason. So I guess my question is just simply, if this is the case where we know this, and again, talking about selective surgeries, cosmetic surgeries and such, is it just trans care that we see these types of attacks going on nationally? And when it comes to, and I know reproductive health care as well, but is it just this group that is being targeted nationally?
I'm Andre Wade, Silver State Equality, for the record. As Senator Scheibel mentioned, for the past 4 or 5 years, for the LGBTQ plus community, those who are transgender, gender diverse, these are the only attacks that we're seeing and that we're concerned about. This is a new patchwork of legal precedents that's occurring because of these bans that have cropped up over the past 5 years. So this is solely new just to this specific group of people, which consists of less than about 1% of the total population. So as a legal landscape, we are figuring this out in real time. So when it comes to something like the interstate compact issue, those are the complicated issues that we have to work through when it comes to shield laws. Because at the end of the day, it's really just about, hey, Texas, you can't come after this person, this provider, through this compact around gender-affirming care just because you have this compact. If it was care that was provided in Nevada under Nevada law, everything's all good as far as Nevada is concerned, it was happening on Nevada soil, then that interstate compact should not interfere solely based upon the care that's being provided. And so that's what we're trying to get around. It is only because of people's coming to terms with what it means to be transgender and what that care looks like, and now for minors, that is now expanding to adults, that we have these hearings about these bills to solve this issue so providers aren't being disciplined, and young people and adults alike can get the care that they need so that they can be healthy individuals.
Thank you, Chair.
Committee members, any additional questions? I don't see any. So thank you for your presentation. If you want to step back. And we will begin with support testimony of Senate Bill 171. I just want to remind everyone that we will be doing 10 minutes here of support, 10 minutes in Las Vegas, and 10 minutes over the phone lines. Each person has 2 minutes. Remember to state and spell your name for the record. You may begin when you're ready.
Good afternoon, Chair and Committee. My name is Sabrina Schnur, S-A-B-R-I-N-A, S-C-H-N-U-R. I am here today on behalf of the Nevada Psychiatric Association, High Sierra Area Health Education Centers, and the Nevada Primary Care Association, which is the state's federally qualified health centers. We see SB 171 as a great way to protect our provider workforce. This bill lets Nevada providers and future providers know that when and if they are properly taking care of our residents, we will ensure they are protected from out-of-state prosecution. There are many residencies going unfilled in other states as providers view those states as not allowing the practice of medicine. This is evidence-based, established medicine, and our providers should be able to do their work without a threat. This makes us a welcoming environment for a diverse healthcare workforce. Thank you.
My name is Karen Thiele, Thiele for the record. I am here representing myself as a private person and a longtime resident in the state of Nevada. I'm a practicing physician here in Northern Nevada. I'm board certified in family medicine, thus I see patients from newborns through geriatrics. I care for a panel of several hundred patients, some of whom receive gender-affirming care from me. I also teach medical students and family medicine residents as part of my job. I would like to tell you why I support this bill. Nevada has a well-known shortage of primary doctors. We need to ensure that the doctors we have stay here, and we need to continue to recruit doctors in order to meet the need of our growing population. This bill addresses both of those needs. If, for example, another state comes after me for providing legal care to one of their residents who has come to my office for that care, my ability to care for the hundreds of other patients that I have is jeopardized. So this bill protects not just me, but the hundreds of Nevadans who count on me as their personal physician. You might think that I could just refuse that care. Not only is that unethical, it is discriminatory in this state to deny services to anyone based on their gender identity. This puts me in a catch-22 situation. Secondly, physicians fleeing states where their practice has been restricted or they have been sanctioned for providing necessary medical care should be able to come here without fear of being unlicensable. I am not here to argue the merit and necessity of gender-affirming care. Frankly, this is not the forum for that discussion. I'm sure you can appreciate that a person's private medical care and consultation with their personal physician should not be up to legislators and should remain in the exam room. Instead, I'm here to point out that protecting your state's physicians from sanctions for providing legal care should be a top priority in a state that already has a shortage of primary care.
Doctor, if you can please wrap up your testimony.
I fail to see how passage of this bill impacts Nevadans in any other way than favorably. I would appreciate confirmation that this state has my back.
Good afternoon, Chair, members of the committee. My name is Davida Tyson, Davida Tyson, and I'm here on behalf of the Nevada Women's Lobby. We strongly support SB 171 because it safeguards medical professionals who are simply doing their jobs, providing legal, evidence-based care in accordance with their training and Nevada regulations. This bill protects healthcare providers in our state from being penalized for offering gender-affirming care that is legal in Nevada. Our doctors, nurses, and licensed professionals should never have to fear legal retaliation, professional discipline, or out-of-state interference for following best practices and acting in the best interests of their patients. SB 171 offers clear protections to ensure that decisions about care remain between a provider and their patient. At a time when medical providers are facing increased pressure from their work, this bill sends a powerful message that Nevada values its healthcare workforce. It also ensures that patients can access treatment without disruption or fear. This legislation helps keep our healthcare system strong and reinforces Nevada's commitment to medical autonomy and professional integrity. We urge you to pass SB 171 and thank you for your leadership and commitment to protecting healthcare in Nevada.
Thank you for your testimony. Once you're done, if you can please get up to allow others to come in and testify as well. Thank you.
Hi, my name is Kimmy Cole. That's K-I-M-I-C-O-L-E. My pronoun is Kimmy. I've been in Nevada since 1956, and I transitioned over 16 years ago. And the way I live my life is I treat others with respect, I work hard, I obey the law, and I pay my taxes. And I retired fairly comfortably, but suddenly a few months ago, I felt like there were targets being painted on my backs. Really? I kind of look forward to retirement, but that's not a reality. And I think, I'm a Nevadan since 1956, and looking around at this group, I imagine you are all Nevadans elected by Nevadans. Are any of you not? Let me see your hands. One of the things I like about Nevada is having the ability to communicate with our representatives so that they can learn the concerns that are on our minds, so that we can have conversations and make this a better state. And it is not in any way to be farmed out to representatives from other states to potentially come in and influence our lives with their perspectives that we may not share. We just simply don't have access to the communications to do that. So I look back, if you're a Nevadan and you were elected by Nevadans to represent us, I want to keep that communications open. I always encourage, if anybody wants to talk to me, most of you know how to get a hold of me, or I know how to get a hold of you. Let's keep it that way and not be playing around with other people kind of trying to come play in our sandbox. I really encourage support of SB 171. Thank you.
Hello, I'm Caroline Mello Robertson, CAROLINE MELLO I'm a lobbyist for Planned Parenthood Votes Nevada. It's always hard to follow Kimmy. I just wanted to thank all the folks here who spoke in support. Thank to the two senators who have come back a second time to do this. I think in a better world, we don't have to do bills like this. People shouldn't be afraid to get what is basic health care for them or provide that care. And that's the world we're living in. So reproductive health care is also in the same boat. And so it's something we live with every day. It's something I think about when I see my face or my child's face on opposition social media, right? So it's something that we unfortunately have to deal with. But this bill will go a long way to saying our values loud and clear. So I hope you all vote in support. Thank you.
Good afternoon. For the record, Brooke, B-R-O-O-K-E, Maylath, M-A-Y-L-A-T-H. I've been a presence in this building, I believe, possibly longer than anybody else on this dais. I'm still the same person. I'm a Nevadan. And one of the problems that we have that has brought this bill forward are the attacks from other states, other jurisdictions, on our providers that jeopardize health care to all Nevadans. But the reason is because some people, some jurisdictions, have questioned my very existence and the existence of people like me. Maybe we make them uncomfortable. Maybe they don't understand. But the attacks that I have heard in these chambers over this session and many others that devalue us, that dehumanize us, that refer to us as animals, is a way to continue to dehumanize us and make us objectives that are eligible for extermination. They're going after our doctors. They're going after your providers. Do you have the right to question my very humanity? Do you have the right to question my ability to get medically necessary health care? Do you have the right to question something that is so intrinsic to my being, my gender identity, my will to express myself to all of society as who I am? Do you really have the right to do that? Because if you do, then I have a question about your humanity and your right to exist, and I don't want to go there. I don't feel I should have that right. Thank you.
Thank you for your testimony. Is there anyone else in Carson City wishing to testify in support? I don't see anyone. I see you sitting in Las Vegas. Please remember to state and spell your name for the record. You may begin when you're ready.
Good afternoon, committee members. My name is Aaron Rook, E-R-I-N-R-O-O-K. I use he, him pronouns, and I live in Assembly District 3. As a transgender public health student who researches suicidality in transgender populations and a member of the World Professional Association for Transgender Health, I cannot overstate the positive effects of access to gender-affirming care to the physical and mental health of transgender people. Protecting this access is more critical now than ever. But the health impacts are only one reason to support SB 171. This bill is also about protecting Nevada's ability to determine its own legal landscape and to protect the lawful practice of medicine in a state that is already struggling to meet the need for providers. If you care about states' rights, you should support this bill. Because what gives Texas the right to bring charges against a Nevada doctor for providing lawful and clinically appropriate care? We didn't elect their attorney general. If you care about individual rights, you should support this bill. I think we all prefer that healthcare decisions should be made between patients and providers, not politicians and police. If you believe that all law-abiding Nevadans deserve to be free from fear of punishment, please support SB 171. This bill not only helps to protect access to life-saving care, it also sends an important message of support to your transgender constituents at a time when we are increasingly under attack. Thank you.
Sorry. My name is Amelia Terry. I'm a lifelong Nevadan who lives in District 8, and I'm here in support of SB 171. Across the country, trans people and their providers are facing growing legal threats for offering or receiving medically necessary, life-saving, evidence-based care that's supported by nearly every major medical association in the U.S. Here in Nevada, we're already experiencing a critical shortage of healthcare providers. Without clear protections, we risk losing even more while making it harder to attract qualified providers. SB 171 helps ensure that providers who offer legal, life-saving care in Nevada are not punished by other states for doing their jobs. It would also protect our healthcare system and reaffirm Nevada's commitment to both individual rights and state autonomy. I respectfully urge your support. Thank you.
Thank you for your testimony. Is there anyone else in Las Vegas wishing to testify in support? Broadcast, is there anyone on the line?
To testify in support for Senate Bill 171, please press star 9 or raise your hand in the Zoom window to take your place in the queue. Again, if you wish to testify in support, please press star 9 or raise your hand in the Zoom window.
Good afternoon, Chair and members of the committee. For the record, my name is Tara Webster, T-A-R-A-W-E-B-S-T-E-R. I'm the policy manager with the Progressive Leadership Alliance of Nevada, calling in support of Senate Bill 171. Plan believes that protecting gender-affirming care spaces and healthcare providers is critical, especially at a time when we're seeing heightened persecution targeting transgender communities. We urge you to vote in support of Senate Bill 171. Good afternoon, Chair and members of the committee. My name is Riley Svensson, R-Y-L-E-Y-S-V-E-N-D-S-E-N, and I am the policy specialist with the Nevada Coalition to End Domestic and Sexual Violence. According to the most recent human rights campaign on the violence that affects the transgender community, 1 in 4 transgender victims were killed by an intimate partner, and 1 in 10 were killed by a friend or family. A study at UCLA showed that transgender people are over 4 times more likely than cisgender people to be victims of violent crime, including rape and sexual assault. Gender-affirming care is critical in both protecting trans people and living a life of dignity. As a state with one of the highest per capita LGBTQ populations, protecting the providers of gender-affirming care is necessary to ensure that such care is available and accessible to Nevadans. It has consistently been shown to improve the quality of life, improve health outcomes, and reduce the rates of sexual assault. Ensuring transgender people have access to gender-affirming care is a critical step in preventing intimate partner violence and sexual violence towards the transgender community and Nevada as a whole. For this, we urge you to support SB 171. Thank you.
Hello, my name is Sarah Lindstrom, S-A-R-A-H-L-I-N-D-S-T-R-O-M, and I am calling in support for SB 171. I have a child who's 8, and we have been seeking an endocrinologist here locally in the northern Nevada, Reno area, and have not been able to find access to them. I also have sought out an endocrinologist, and I have had a referral for, I think, since it was April of last year, and I still have not been able to get into an endocrinologist today because there just is a huge shortage of endocrinologists available. My child had to seek care out in Stanford for his medical needs or transgender transitioning. I mean, we're really looking at puberty blockers at this point, but it hasn't been available in our area because first, I know that they are scared to help us. I have spoken with an endocrinologist and they didn't really want to give us care. They did refer us away to Stanford, and I think that that's just not fair that my child can't get the care that he requires. At the age of 6, he had spoken about suicide and had some self-harming incidences, and we took him in to see a psychiatrist. And once all the gender information had been kind of put to rest and he started calling himself he, that fear kind of went away. And I do know that I need to have puberty blockers moving into puberty. So
ma'am, if I can please have you wrap up your testimony.
Yeah, if you can all vote in support of SB 171, I would truly appreciate having doctors available for the care that we need.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Caller with the last 3 digits 349, please press *6 to unmute yourself.
Hi, good afternoon. My name is Tia Smith, TIA-SMITH. I'm a policy attorney with ACLU of Nevada. We will submit written comments, so I'll keep this short and say ACLU of Nevada supports this bill, and we urge the committee to support as well. Thank you.
Good afternoon, Chair and members of the committee. I am Leanne McAllister, MCALLIFTER. I am the Executive Director of the Nevada chapter of the American Academy of Pediatrics. While it's true, I do not personally know of any pediatricians yet in the state of Nevada who have been extradited or received charges from other states. I have met dozens of pediatricians and other physicians who are afraid exactly that may happen. For the past 2 years, we have seen so many examples of things that have never happened before that are now happening involving government overreach into evidence-based healthcare. I urge you to support SB 171.
Good afternoon, Chair Marzola, Vice Chair Hagahi, and members of the Assembly Commerce and Labor Committee. For the record, I'm David Parks, DAVID, PARKS. Without being redundant, I would simply like to voice my strong support for the passage of Senate Bill 171 and sincerely thank Senator Orenshaw for introducing this bill, which establishes a law protecting Nevada's licensed medical providers who provide medically necessary gender-affirming health care. We don't need other states to impose their laws on Nevada. Thank you for the privilege of your time.
Hi, good afternoon. My name is Scott Callahan, SCOTTCALLAGHAN, and I'm testifying in support of SB 171. You know, it's a difficult time to be a transgender American, and so I think it's critical to pass this bill. You know, it expand on some of the protections we already have in Nevada for the transgender community. enable individuals to make their own decisions on medically necessary health care without having the government involved. And we've seen, we've already talked about many of the examples of how, states such as Texas are already willing to go after other states to try to enforce their local bans. The other thing I just wanted to add too is that, a number of transgender Americans are relocating from states with hostile environments to states with more welcoming environments. And one of the things that passing this bill does is it shows that community that we in Nevada are welcoming to all and that we believe in everyone's right to make their own healthcare decisions. Thank you very much.
Good afternoon, Chair Marzola and committee members. For the record, my name is Matilda Miller. That's Mathilda Miller, Government Relations Director of Native Voters Alliance Nevada, and we are in strong support of Senate Bill 171. At its heart, this bill is about protecting providers who are doing exactly what they were trained and trusted to do, to heal, to deliver evidence-based care, and to center the well-being of their patients. This body must protect the patients who come to our great state in search of care that their home states may have banned under laws rooted not in medicine, but in cruelty and fear. These are patients who are navigating impossible decisions just to access the care that they need. And in the same way that you expect your doctor to fight for your life, providers who are offering gender affirming care are doing the same exact thing for theirs. This bill ensures that they don't have to do that work while looking over their shoulder. We urge for your support. Thank you.
Chair, we have no more callers for support at this time.
Thank you. We will move to testimony in opposition of Senate Bill 171. Is there anyone in Carson City wishing to testify in opposition? Good afternoon. Please remember to state and spell your name for the record. You each have 2 minutes.
Thank you, Madam Chair. My name is Janine Hansen. I'm the state president of Nevada Families for Freedom, and I am a native Nevadan, and I have been a citizen lobbyist in this building every session since I was 19. I'd like to share the story of Jamie Reed. She was a worker for 4 years at the Pediatric Transgender Center in Washington University in the St. Louis Children's Hospital. She said, "I have decided to come forward," when she made a complaint to the Attorney General, "to report serious concerns I have about medical care being provided by the center, causing harm to patients and their families. This includes rapid medicalization of children, poor assessments of mental health concerns prior to the provision of gender-altering treatment, medicalization of children without prior and adequate therapeutic treatment, lack of appropriate informed written consent from parents and youth, and permanent irreversible harm and injury caused by the medical treatment provided by the center." There is a lot of money involved in this particular kind of medicine, and so there are bad actors. We in Nevada do not want to become a sanctuary state for bad doctors. We also oppose the section which takes away the governor's authority, his constitutional authority. Thank you very much.
Thank you. Good afternoon, Chair and Committee. My name is Joshua Skaggs, and I'm the Legislative Affairs Director for the Nevada Republican Party in opposition to SB 171. This bill is an attempt to repass SB 302 of the 2023 session, which was vetoed by the governor. In his veto statement, the governor noted that the problem with the bill was that it inhibited the executive branch's ability to be certain that all gender-affirming care related to minors comports with state law. It also decreases the executive branch's authority to ensure the highest public health and child safety standards for Nevadans. Despite the wording on parental or minor consent added in Section 1, the remaining language in Section 1, subsection 2 remains unchanged from the previous bill and makes it clear that the bill continues to be targeted to procedures performed on minors. Section 2 of the bill continues to inhibit the executive branch's ability to protect Nevadans, particularly minors facing permanent life-changing procedures without their consent, from being victimized by bad practitioners. The Nevada Republican Party does not support gender transition surgeries and the prescribing of puberty blockers to children who are not old enough to understand the issue or give consent. Isn't it misrepresentation to claim a procedure is medically necessary when it is, in fact, cosmetic surgery performed to address a psychological condition known as gender dysphoria, particularly when a significant amount of research shows that such procedures do not reliably relieve distress long term. In Europe, an increasing number of countries have banned these procedures because the risk outweigh the benefits. Here in the United States, 26 states have banned gender-affirming procedures for minors for these reasons, and we pray Nevada becomes the 27th. As we did in the last session, we urge a no vote on this dangerous legislation. Thank you.
Yolanda Knock, Yolanda, last name Knaak. This letter is from the Nevada Federation of Republican Women regarding our opposition to SB 171, gender affirming care. The Nevada Federation of Republican Women represents 18 clubs statewide and more than 1,500 members. We strongly oppose gender affirming care for minors. We have a resolution that opposes gender affirming care for minors. Our resolution was adopted March 4th, 2023. Besides this bill, including gender affirming care for minors, the bill removes the governor's rightful authority and disrespects the law of other states. Again, we strongly oppose SB 171. We respectfully ask for a no vote. Thank you, Nevada Federation of Republican Women.
Thank you for your testimony. Is there anyone else in Carson City wishing to testify in opposition? I don't see anyone. I see you sitting in Las Vegas. You may begin when you're ready.
Good afternoon, members of the committee. Thanks, Madam Chair. My name is Cristiane Mersch, M-E-R-S-C-H, on behalf of Bienvenido, the largest Hispanic community here in Nevada. We extremely oppose SB 171 because this bill would make Nevada a sanctuary state for individuals and medical providers involved in these transgender surgeries and even those who are facing legal action in other states for performing irreversible interventions on minors. We witness across the state and in America how these procedures are harmful for kids. So this bill was already vetoed by Governor Lombardo under SB 302. And his words, he said this would take away his constitutional rights. Also, he stated that clear that the executive branch must retain the ability to ensure that any such care complies with the state law and protects child safety. And SB 171 undermines that principle, and more importantly, undermines the U.S. Constitution. Under Article 4, Section 2, the extradition clause gives the governor a duty to cooperate with other states when someone is charged with a crime and flees here. But this bill would forbid the governor from doing so in cases involving gender affirming care, even those actions are criminal in the state where they occurred. This is a dangerous precedent and we cannot pass. It undermines the state cooperation. Please, I urge you to vote no on SB 171. To not tie the hands of our governor. Do not make Nevada a safe harbor for those who may have harmed vulnerable minors. Thank you.
Is there anyone else in Las Vegas wishing to testify in opposition? Broadcast, is there anyone on the line?
To testify in opposition to Senate Bill 171, please press star 9 or raise your hand in the Zoom window to take your place in the queue. Again, if you wish to testify in opposition, please press star 9 or raise your hand in the Zoom window.
Good afternoon, Chair and members of the committee. I'm Kimberly Fergus, F-E-R-G-U-S. I respectfully oppose SB 171 for the following reasons. It blocks oversight. This bill prevents Nevada licensing boards from considering disciplinary actions taken in other states, even if those actions involve serious medical violations or patient's harm. It also erodes medical standards. Licensing should be based on a provider's full record. Shielding misconduct because it occurred elsewhere undermines our state's responsibility to uphold quality care. It also assures all discipline is political. This is a dangerous assumption. Not all sanctions are unjust, and this bill removes the ability to tell the difference. Medicine depends on accountability. SB 171 turns a blind eye to real violations in the name of political protection. For patient safety and ethical oversight, I urge a no vote on SB 171. Thank you. Have a good day.
Good afternoon. My name is Lynn Chapman, Lynnchapman, and I'm the State Treasurer of the Independent American Party. What people do when they are 18 years and older is their business. However, the state of Nevada has a duty to protect its citizens. We do need doctors to come to Nevada and practice medicine, but the state of Nevada has a duty to protect its citizens. A doctor who performs surgeries in another state and that state ends up having charges filed against that doctor should not be able to come to our state and be protected. What kind of doctors will we end up having in our state then? Very concerning to us is that this bill prohibits the governor from extraditing an alleged criminal. Our governor was elected to make sure we as Nevadans are protected. Section 3 discusses the fact that Nevada will not be permitted to expend any resources in the furtherance of investigations initiated in or by another state. Sure hope we don't need other states to help us when we need it. The people of Nevada elected the governor and expect him to be able to do his job. So stop trying to tie his hands so he can't do the job he was elected to do. Nevadans don't need this bill. Vote no on SB 171. Thank you.
Good afternoon, Chair Marzola and committee. My name is Teresa DeGraffenreid, T-H-E-R-E-S-A, DeGraffenreid, D-E-G-R-A-F-F-E-N-R-E-I-D. I'm in opposition of SB 171. At its core, SB 171 is an unnecessary political statement. No other state is prosecuting doctors or pulling their licenses for performing legal procedures in Nevada that might be illegal in that state. And to suggest that they are is misleading at best. That would be equivalent of a state where gambling is illegal, attempting to prosecute a resident of that state for gambling while on vacation in Las Vegas, or to prosecute a casino for allowing an out-of-state resident to gamble here. But we all know that doesn't happen either. Examples were given today of inappropriate attempts by Texas and other states to prosecute actions taken elsewhere. But as was mentioned, these efforts have been correctly shut down due to states' recognized rights to control actions within their borders. On the flip side, especially since Nevada permissive laws are in a majority among the states, Nevada should not attempt to extend our authority beyond the Nevada state line either, which is exactly what this bill attempts to do. Additionally, this bill in sections 1, 2, and 3 excludes conversion care from the definition of what the bill calls gender-affirming care, and we feel these subsections should be stricken. As mentioned in the bill itself, gender dysphoria is a defined mental condition, and mental health treatment should not be discarded in favor of permanent life-changing
Ma'am, can you please wrap up your
interventions
testimony? Your time has ended.
Yep. Performed on minors who are too young to consent. We urge the committee to not support this dangerous bill.
Thank
Vote
you for
no.
your testimony.
Thank you.
Broadcast, is there anyone else on the line?
Thank you, committee, for this opportunity to express my opposition to Senate Bill 171. My name is Cynthia Perrine, Cynthia PERINE. I would like to alert listeners to the fact that this law could well violate the extradition clause of the U.S. Constitution because it may effectively block Nevada from complying with a valid extradition request under federal law. Such shield laws regarding gender-affirming care are a developing legal area and of dubious enforceability. Why do we need a law for a problem that has few instances of occurrence? It is at best a what-if law. Moreover, many medical treatments once considered medically necessary are now coming into question, as previous speakers have explained. For this reason, I ask the committee to oppose SB 171. Thank you.
I'm Tim Underwood, Senior Advisor to Moms for Liberty, Clark County, and a parent of a trans child, and I oppose SB 171, the two-tiered justice system for child castrators bill. There is no medical necessity for gender-affirming surgeries on Nevada's children. This legislature has fallen for a major medical scandal, as shown by the WPATH files, which are leaked documents revealing WPATH's transgender healthcare standards lack scientific backing. Additionally, there's the CAST review in England, an independent study that led to banning such care for minors in the United Kingdom, with many European nations following. These are easily verifiable online. Nevada assemblymen or committee members will be held accountable for their voices on this critical family issue. Now, this is not a political, but a scientific fact shaping global gender policies. By denying biological sex, this legislative body undermines its legal and scientific legitimacy. It must repeal all transgender-related policies that defy science. Morally, promoting transgenderism for young children is wrong and politically very unpopular. Only 20% of your voters support state-sanctioned surgeries for kids, a 5-to-1 issue, meaning over half of Democrat voters oppose this.
Sir, can you please wrap up your testimony? Your time has ended.
Okay. I would just urge this body to return to science and medicine and get away from this political...
Thank you for your testimony broadcast. Is there anyone else on the line?
My name is Dr. Eric Nelson. I'm a forensic criminologist, and also by training, I'm a social psychologist. I live in Senate District 17. Nevada should not give special protection to therapists, physicians, or surgeons who are mutilating children and adults. Their work is increasing the suicide rate of their patients. Their work is irreversible. Victims cannot get amputated body parts back. Little girls can't get their breasts back or a feminine voice. Little boys cannot get their amputated parts back, and the victims are sterile for life. Let's not make Nevada a refuge for surgeons who perform mutilations and amputations and therapists who affirm the delusions of children and adults who are mentally ill. The suicide rate increases substantially for people who are being amputated, implanted, or drugged with powerful substances. The supporters today have not told you the deadly other half of the story. I'm calling in today in honor of my friend Mark, who, after amputations, implants, and chemicals, did not become a woman. The lie that he could become a woman eventually drove Mark to suicide. Shame on the surgeons and therapists who operated on him and who affirmed his is gender dysphoria. And I plead with you, please, for the love of sanity, do not support SB 171. Thank you very much.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Hi, my name is Katrin Ivanov, Ivano Frank, and I strongly urge you to oppose SB 171. The presenter said that this bill will affect 7,000 medical providers, yet no one other medical provider saw it necessary to come and express their support for this bill next to him, her, I don't know, I'm not doing it on purpose. I don't know what to call because he has different. Anyway, when I study English is my 4th out of 7 languages. I didn't study that I call one person plural, so it's a little bit confusing. I apologize. I don't mean to hurt anybody's feelings. That's why I'm calling it presenter. I don't know if I should call it presenters, but out of 7,000 people, nobody went next to him, next to the presenter to express support. I find that interesting. That bill is, to use one of the other presenters' words, a glorified gossip chain. We were given, and again, that bill is more about people from out of our state versus people from our state. The one sample that was given was a man from Florida. Florida legislature passed bills that are in regards to Florida citizens. That's why they have a robust election system, and we are ashamed to the whole country. Nevada is ashamed because our legislators choose to spend their time passing bills that are regarding to other people other than Nevadans. We have so many problems. We are last or at the best 48 out of 50 states in education. We are last.
Ma'am, can you please wrap up your testimony? Your time has ended.
Yes. Please vote no on this bill. It does not solve any problems. It just creates more.
Thank you for your testimony.
Money.
Broadcast, is there anyone else on the line?
CYRUS, HOJJATY. I am calling in opposition. I will echo many other comments. Great pleasure.
Chair, we have no more callers for opposition at this time.
Thank you. We will move to neutral testimony of Senate Bill 171. Is there anyone in Carson City wishing to testify in neutral? I don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line?
Testify in neutral to Senate Bill 171. Please press star 9 or raise your hand in the Zoom window to take your place in the queue. Caller with the last 3 digits 513, please press star 6 to unmute yourself.
Good afternoon, Chair and committee members. This is Jessica Munger, MUNGER, from Silver State Equality. I want to clarify that my testimony is in support of SB 171. Apologies for that.
And
ma'am, I want to say thank you.
Ma'am, we have closed support testimony, so if you would like to submit your support testimony in writing, please feel free to do so to the committee secretary, and we will make sure to make it available for all the committee members. Broadcast, is there anyone on the line for neutral testimony?
Chair, we have no callers for neutral at this time.
Thank you. Senator, would you like to give any final remarks?
Thank you, Chair Marzola, members of the Assembly Committee on Commerce and Labor. James Orenthal, Senate District 21.
I think 10, 15 years ago, it would have been unthinkable that we need a state shield law to protect patients and healthcare providers from other states trying to intervene through their laws, through their disciplinary actions against legal healthcare in Nevada. But here we are. And to address some of the comments some of the callers made, some of the opposition, Senate Bill 171 doesn't change anything about what's legal healthcare in Nevada. Doesn't change what would or would not be allowed for minors with or without parental consent. As to discipline, if a healthcare provider is accused in another state of malpractice, that could certainly be investigated by a disciplinary board in this state. But it's where that other state has made legal gender-affirming care in Nevada a crime, that is something that would not subject that healthcare provider to sanction or to discipline in Nevada. One of the callers called this a what-if law, that there was no justification for it, that maybe no one had another state reach in against their medical licensor here in Nevada. Certainly, we've heard testimony about physicians, healthcare providers who are terrified and scared to come to a state without a shield law to practice. And this not only affects gender-affirming care and patients seeking it, it affects all sorts of other health care. As we saw Rob Phoenix testify, that he doesn't just provide gender-affirming care, he provides health care, general practice to his patients. With your permission, Chair Marzola, if I could turn over the rest of the closing to Andre Wade from Silver State Equality.
Thank you, Chair Marzola and members of the committee. Thank you for your attention and your thoughtful questions. Even appreciate the opposition and their remarks. Just to underscore what Senator Orenshaw said, this is a preventative measure. We know that in healthcare and in human services, prevention is cost effective, and better. So we are trying to get ahead of the issue. Our legislature meets every other year. So in the interim, anything could happen with other states who are trying to expand their laws. So while the iron is hot, we need to pass this bill so we can get it signed into law and have protections for our providers of healthcare. And one last thing I'd like to clarify about Europe. Back in December 2024, the French Society of Pediatric Endocrinologists and Diabetology released a statement in support of gender-affirming care, and also similar guidelines in Germany, Austria, and Switzerland. And there are a lot of issues with the CAS review. A lot of them have to do with the methodologies that they got to their conclusions. And so we don't want to lean on that as any reason to think differently about gender-affirming care. But lastly, I'll say we're not here to debate gender-affirming care. It's legally provided in the state of Nevada. It's covered by insurance companies. We are here to protect patients and providers. So thank you again.
Thank you, Chair. Thank you, Committee.
Thank you for your presentation today. And exactly what Mr. Wade stated, this bill is about the protection of patients and doctors that we already have a huge shortage of. Not doctors, just healthcare providers in general. For as long as I can remember, and I'm sure everyone in this committee room, people have been discriminated against. Native Americans, African Americans, women, immigrants, now the transgender community. And I know there are others that I'm leaving out, but just to name a few. That's unacceptable. At the end of the day, we are all humans, and that's what matters. Someone stated earlier that they prayed that this bill wouldn't move forward. Well, I pray that one day we all stop hating each other the way we do, and lives lost because of the hate. That's what I hope, that we all can come together in peace, no matter the color of your skin, who you like, who you identify with, or your sex. And with that, I close the hearing on Senate Bill 171. 1 minute recess. Committee is back to order. I will now open a hearing on Senate Bill 258, which revises provisions relating to industrial insurance. Good afternoon, Senator Nguyen, Mrs. Brazier, and Mr. Miller, or Mills. Sorry, it's been a long day. Oh, that's a lot worse. You may begin when you're ready.
Thank you, Chair Marzola and members of the committee. I'm Rochelle Nguyen, and I represent Senate District 3 in Clark County. I'm presenting Senate Bill 258, which revises provisions related to industrial insurance, otherwise known as workers' compensation. I have with me today Jason Mills and Senate District 3 constituent Allison Brazier. And before I turn this over to them to present, I'd just like to thank all of the parties that came and really worked on this bill to get it into a place. It was a very unique perspective and experience for me because I had two constituents on opposite sides that were able to come together and do a bill. So I see one of my other constituents, Dalton Hooks, who I had the pleasure of going to law school with as well at Boyd School of Law, Go Rebels, also in the audience and that worked on this. So I just wanted to thank everyone. And with that, I will turn this over to Ms. Brazier.
Good afternoon, Allison Brazier for the record, B-R-A-S-I-E-R, on behalf of Nevada Justice Association. I just want to briefly explain for the committee the types of cases that this bill would affect and a history of how we got here, and then I'll turn it over to Mr. Mills to explain how the bill works. So the only types of cases that this bill would affect would be workers' compensation cases that also have a tort element to them. So these are cases where you have a good employee, a good employer, but a third party acts negligently and causes harm while that person is on the job. So some examples of those types of situations would be a police officer who is pulled over on the side of the road and gets hit by another vehicle. Or a plumber who's working inside someone's house and gets bit by that homeowner's dog, or a valet who's working in the valet area gets hit by a customer who's driving through the valet. So it's just those workers' compensation claims that also have a third party who is the one who has caused the harm. So the issue that this bill addresses is when you have that situation where the work comp carrier pays benefit to the injured worker, but there's also a recovery from a third party. How does that work comp lien get addressed, and how much is paid back to the work comp carrier for the benefits that they've already paid? And in 1986, the Nevada Supreme Court came out with a case that we all refer to as Breen that created a formula which provided for an equitable distribution of procurement costs between the claimant and the insurer. And we all operated in this state since 1986 under the formula that law created. Until last September when the Supreme Court came out with a case called Vasquez. And the Vasquez case looked at Breen and another case that dealt with this world called Paremba. And they didn't say that either of those holdings or that formula was bad. They just said this is a question for the legislature to answer. The Supreme Court should not be deciding how these liens get paid. So that is why we are here before you today, is to address that issue. Some of the criticisms that those of us who operated under the Breen system had of the formula was that there was a certain element of uncertainty to how that formula would play out in each case because there were different factors that were considered. So a different case could have a different outcome than something that had a little bit factually different scenario. So this bill, while it is similar to Breen in that it creates a formula for everyone to work under, I think really simplifies that formula, and it gives predictability to everyone involved in the system. And that's for past benefits that have been paid and also future benefits. So it gives an element of predictability to both the insurers and the claimants. Under the current state of the law with Vasquez, the injured worker could literally recover nothing if they decide to pursue a claim against that third party who caused them harm. Under Vasquez, they could get zero from from pursuing that claim. And so this bill will fix that. It will simplify and bring certainty and equity to all parties in the system. And again, just so that everyone is clear on it, this only applies to those situations where there's a recovery from a third party. It does not affect any other of your just run-of-the-mill workers' comp case. So I'll turn over to Mr. Mills to explain how that bill accomplishes this.
Thank you, Madam Chair. Jason Mills, JASON-MILLS, on behalf of the Nevada Justice Association. I appreciate the time that you've given us today along with your committee, and I wanted to thank Senator Wynn for bringing this much-needed bill, as well as the stakeholders that came together to make this happen. The Nevada Resort Association, the Nevada Self-Insured Association, Employers Insurance, self-insured groups such as Pro Group and TPAs like Nevada Alternative Solutions. It was invaluable to have their input to have this bill get to where it is now and leave the Senate in the state of 21-0 passage over to here. I would like to tell you that essentially what this bill does is the following 4 things. One, you have to remember that there is not a scenario where these rules would exist if there was unlimited recovery. If there were unlimited recovery, this wouldn't be a law and we wouldn't have to have it. However, the reality is most cases do not have unlimited recovery by the victim in the tort case. So what happens is when the industrial insurer pays out, now what's going to happen is either they're going to receive their lien, the entirety of their lien, if there's sufficient funds. If there's not sufficient funds, then they will receive up to 1/3 of the recovery of the tort proceeds. Simple, and all parties agreed to that. Next, there are only 2 parties that recover in these scenarios, the claimant and the insurers. So in order to procure the costs of the recovery, both sides are going to equally share in the costs of that recovery. However, if the insurers or employers disagree with those costs, they have a right to go directly to court to challenge them. Next, it addresses, and finally, the issue of reopening in the future. We call that offset. What that deals with is in scenarios after the tort has resolved, the monies have been paid out in the subrogation, but the claim reopens. That is not special or unique to this bill or rule. We've had reopening rights in workers' compensation for decades. Our laws date back to 1911, so there's no change on our reopening rights here. But what it does do is it recognizes that if in the future the claim reopens, they won't have their medical benefits halted, and their indemnity payments, their short-term disability, their long-term disability payments, would be reduced by 1/3 until the total recovery that the claimant received in tort that they personally netted is completely offset, and then the insurer would be able to then essentially, legally, recapture everything they paid out. That's what this bill does. It is a balancing act between all of the parties involved, and I just, again, wanted to appreciate the time that the Senator put in and all the stakeholders. If there are any questions of us, we're prepared to answer them.
Thank you for the presentation. Are you going to go through the entirety of the bill?
Jason Mills, Chair. No, unless you'd like me to.
I would usually say yes, please go through it, but it is Friday, so I'm going to spare you today. Thank you for the presentation. Committee members, are there any questions? Speaker Yeager.
Thank you, Chair. I don't have a question. I just wanted to commend the parties involved. I know when this decision came out, there was a bit of chaos because you relied on this formula for such a long period of time. But I think this is a demonstration of how this building works in its ideal form, that you got everyone in a room and figure this out. So just want to thank you for those efforts, because now we're here with what I think is a consensus bill and not trying to figure this out in the last 30 days of session. So thank you for getting ahead of this issue and for involving all those in the room who are interested in this topic.
Any questions or comments? I don't see any. You guys got it easy today. We will start with support testimony of Senate Bill 258. Is there anyone in Carson City wishing to testify in support?
Good morning, Madam Chair, members of the committee. Thank you for taking the time to hear this bill. I'm Tom Morley, T-O-M-M-O-R-L-Y, representing laborers 169 and Teamsters Local 631. We're in support. Thank you.
Thank you, Chair Marzola, committee members.
Misty Grimmer for the record, Grimmer, representing the Nevada Resort Association. You know, a lot of times there's not questions on work comp because everybody's eyes glaze over. But we are in support of the bill and definitely appreciate how the NJA was open to getting, and the bill sponsor were open to getting everybody at the table together to really work out all the details. We have a long history of doing that in workers' comp, which is one of the last topics in the building where that kind of collaboration still happens. And so we are in support of the bill. Thank you.
John Noble with Employers Insurance, here in support. Just want to thank the sponsor and everybody involved for getting this language together and pushing it through the legislature. Thanks.
Good afternoon, Madam Chair, members of the committee. For the record, Andy McCam, the Executive Director of the Nevada Franchise Auto Dealers Association. We have a self-insured group that is managed through Pro Group, and wanted to put it on the record and thank Senator Nguyen, particularly Jason Mills, for working with everybody and coming to, I think, Mr. Yeager, if I mischaracterizing, you said consensus piece of legislation or something thereabout. And what Ms. Grimmer said is absolutely accurate. This is the way the process is supposed to work. And so I just want to put it on the record and thank the parties for working with us, and we support the bill.
Madam Chair, members of the committee, for the record, I'm Paul Enos. I'm the CEO of the Nevada Trucking Association, here today in support of Senate Bill 258. We also have a self-insured group that is managed through Pro Group. Our folks tend to be involved in these cases that are subrogated when there's a vehicle accident. So we appreciate this bill coming forward. We appreciate the work of the sponsor and the other proponents to have some consistency in this area of the law. Thank you.
Good afternoon, committee chair. Todd Inglesby, president of Professional Firefighters Nevada. I want to thank the senator for bringing this, thank the committee for hearing this. This is important legislation to make it right for workers and our businesses that employ those workers. So we appreciate that and look forward to having this passed. Thank you.
Madam Chair, members of the committee, Jason Lesher with the Washoe County Sheriff Deputies Association and the Public Safety Alliance of Nevada. We are in support of this bill. Thank you.
Thank you for your testimony. Is there anyone else in Carson City wishing to testify in support? I don't see any. I see you seated in Las Vegas. You may begin when you're ready.
Chair Marzola, members of the committee, my name is Charles Nort. I am here on behalf of representing NAS, Nevada Alternative Solutions, iGaming, and TNR Construction Group. That said, I want to echo the comments of Mr. Mills and specifically Senator Nguyen in bringing the hard work and all the stakeholders that have participated in this and bringing this to a conclusion that everyone is in agreement with, I feel. That said, we are in support of SB 258, and I thank you for your time.
Good evening, Madam Chair, members of the committee. Dalton Hooks, H-O-O-K-S, with Hooks, Mang, and Clement. Here on behalf of the Nevada Self-Insurers Association, I want to thank my classmate, Senator Nguyen, Go Rebels, and Mr. Mills for their work regarding this bill. We are fortunate enough to have litigated this case with Mr. Mills that brought us here today. This is a solution that is certainly a consensus solution to try and resolve this, and we're happy for the work that we were able to do with all of the stakeholders, and so we are here in full support. Thank you.
Thank you for your testimony. Is there anyone else in Las Vegas wishing to testify in support? Broadcast, is there anyone on the line?
Thank you, Chair. If you would like to testify in support of Senate Bill 258, please press *9 now to join the queue. Caller ending in 982, you were unmuted. Please proceed when ready.
Good afternoon, members of the committee. My name is John Abel, John-Abel, representing the LVPPA. I want to thank Jason Mills and the bill sponsor for this bill. I know they put a lot of hard work into it. Workers' comp is definitely an issue that police officers face all the time. And so, again, we want to thank the bill sponsors and stakeholders as we support this bill. Thanks so much.
Chair, there are no additional callers choosing to testify at this time.
Thank you. We will move to opposition testimony. Is there anyone in Carson City wishing to testify in opposition? I don't see anyone. Is there anyone in Las Vegas wishing to testify in opposition? Broadcast, is there anyone on the line?
If you would like to testify in opposition to Senate Bill 258, please press star 9 now to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. No opposition on a work comp bill. There was a lot of work done. We will move to neutral testimony. Is there anyone in Carson City wishing to testify in neutral? I don't see anyone. Is there anyone in Las Vegas wishing to testify in neutral? Broadcast, is there anyone on the line?
If you would like to testify in neutral for Senate Bill 258, please press star 9 now to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. Senator, would you like to give any closing remarks? I will now close the hearing. On Senate Bill 258. I will now open up for public comment. Please address your remarks to issues that fall within the jurisdiction of this committee. Please remember that public comment is limited to 2 minutes per person. Is there anyone in Carson City wishing to give public comment? I don't see anyone. Is there anyone in Las Vegas? Broadcast, is there anyone on the line?
If you would like to provide public comment, please press star 9 to take your place in the queue.
Hi, my name is Katerina Ivanov, Ivano Frank. And since you guys working on workers' comp, is there any questions?
Are you giving public comment?
No. Oh, yeah, yes, I'm giving public comment. I'm not talking about the bill that you just presented.
Okay, if you would like to give public comment, you may begin. You have 2 minutes.
Yes. Do I need to spell my name again or no?
No, that's fine.
Okay, so I wanted to say that since you guys work on workers' comp, maybe you can look into streaming workers' comp ways, because I will give you me as an example, but I'm sure other people have similar experience. I broke my foot in January in 2023, yet every time I need therapy, it takes another 30 days, because workers' comp is allowed to have 30 days before they answer. So I am literally, and it took them until 5 months ago to even allow therapy for me to start walking again. So every month I have a 1 month of therapy, and then I have a month of break, month of therapy, month of break, which obviously slows down the therapy. So if you guys can come up with something that they don't have to wait for 30 days to answer, they should answer timely. Or also the doctor is not allowed to give me more than 30 days of therapy. Maybe if you know it's a broken foot, you know it's going to need more than 1 month of therapy, the doctor should be allowed to give more therapy, especially if it takes them another month to answer. And I also wanted to congratulate the chair, because in my opinion, the chair is in support of SB 171. However, she did follow the rules and didn't allow people to speak when it wasn't their turn to speak. Although I did like more the chair for the election committee that allowed everybody to speak a lot. Thank you, and great work, everybody, and hope to talk to you soon. Have a lovely weekend. Bye.
Chair, there are no additional callers to provide public comment at this time.
Thank you. That will conclude our meeting for today. Our next meeting is Monday on May 5th. This meeting's adjourned.